Well, good morning, everybody. Good morning, Commissioner Hayward. All right,
Good morning.
Good morning. All right, let's go ahead and get started. This is our Law and Policy Committee meeting. Ms. Linker, would you please call the roll?
Commissioner Hayward?
Here.
Chair Matich?
Here. We'll go ahead and proceed to item number 1, and that is public comment for items not on the agenda. Do we have any public comment either on the telephone line or through our digital public participation portal? Hearing none, we'll move to item number 2, approval of the previous Law and Policy Committee meetings. We'll begin with the February 5th, 2020 meeting minutes. Commissioner Hayward, do you have any edits or comments to the meeting minutes?
No, and I would move approval.
All right, do we have any public comment on the meeting minutes? Hearing and seeing none, I'll second the motion. Ms. Linker?
Commissioner Hayward?
Aye.
Chair Matich?
Aye.
Motion passes.
Moving to the March 11th, 2020 meeting minutes. Any comments or edits for the March 11th meeting minutes?
Not for me. Again, I'd move approval.
Any public comment on the March 11th meeting minutes? Hearing and seeing none. Ms. Linker, would you call the roll?
Commissioner Hayward?
Aye.
Chair Matich?
Aye.
The motion passes.
Moving to item number 3, this is our interested persons meeting for limited liability companies. For the benefit of the public that may be listening or watching our proceedings, the Commission has expressed over the last several months interest in potentially amending or adding new regulations with respect to limited liability companies and their participation in state and local elections. We also, through our legislative program, have identified a number of potential legislative proposals related to LLCs. This is our first interested persons meeting where we can obtain more feedback from the regulated community and the public in general on this issue. I know we have Torrin Lewis, Commission Counsel, with us, who had presented at one of our prior meetings, including presenting, I think, some very interesting information about the use of LLCs as ways of potentially sort of circumventing normal transparency rules that we have in California. Mr. Lewis, I don't know if you have a presentation for us today or if you're here simply to answer questions and respond to comments.
Yeah, good morning, Mr. Chairman and Commissioner Hayward. I do have a brief presentation if you'd like, but I'm happy to defer to what you'd like to do.
No, please, go for it, Mr. Lewis. Thank you.
Certainly. So again, Torrin Lewis with the Legal Division. I'm just going to be talking briefly about the issue of disclosure by limited liability companies who participate in political activity in California elections. So the issue, as has been discussed in at least one other previous commission meeting, is that current law enables LLCs to make contributions or independent expenditures solely in the name of the LLC without actually disclosing the source of the funds or naming any individual that is a natural person who is responsible either for operating the LLC or for approving its political expenditures. And this lack of information around LLC contributions and expenditures is largely due to existing corporate laws that require very little information from LLCs about their formation, their funding, their management and operation. And that includes not actually requiring any disclosure of who is an LLC's manager or managers plural until 90 days after its formation. And so in response to this issue, we as staff have proposed a couple different legislative and regulatory solutions. I should note that before discussing the legislative ideas, that currently the legislature is essentially on hold due to the whole COVID-19 situation. And so it's our understanding that as of now, they're shifting their focus to areas related to COVID response, such as budget and economic recovery. But that being said, I still want to highlight some of the legislative ideas that our legislative director, Phil Ung, largely came up with prior to his departure. And so one is or was, I'm not sure as the current status of this bill, AB 2407, and the author of that is Assembly Member Berman. And this would require a committee to include in its campaign statement the name of each individual who owns or controls the contributions or expenditures of an LLC. And this is quite similar to our proposed regulation 1842110, which I'll go over in a moment. So that's one legislative idea. Another would be to create additional disclosure requirements for LLCs who participate in political activity. For example, requiring LLCs to disclose the individual who controls the political activity similar to the principal officer requirements currently in the Act, or deeming an LLC a recipient committee under certain circumstances, such as when capital contributions are made within a certain time frame of an LLC making contributions or expenditures. And finally, another legislative idea was to require LLCs who make contributions or expenditures to disclose all direct or indirect owners with membership interest in the LLC by submitting essentially what would be a statement of identity with the Secretary of State's Political Reform Division. And obviously that would have to be done in consultation with SOS. So those are the legislative ideas. Again, not sure, Mr. Chairman and Commissioner Hayward, if you want to discuss those further given the status of the legislature, but I'll pause there in case there's any questions on the legislative front. Okay.
No questions. Mr. Lewis, I think focusing on the regulatory proposals at this point makes the most sense. Thank you.
Great, that makes sense. So in terms of what we can do as staff and the commission from a regulatory angle, staff has drafted proposed regulations 18402.2, and this is titled Limited Liability Companies Responsible Officer. And this first proposed regulation would define who is a responsible officer for LLCs that qualify under the current IE committee and major donor thresholds. So in other words, it would define that as the individual primarily responsible for approving the political activity of the LLC. This reg, as currently drafted, would also require that if there's more than one such individual, at least one of them would have to be named, since it's probably the case that often there's multiple. And secondly, proposed regulation 1842110, reporting contributions from limited liability companies, addresses the issue where a committee receives contributions from an LLC, and this proposed regulation would require that such a committee would have to include as part of a contributor's name on its campaign statement the individual responsible for the LLC's political activity. So currently in the name field, I believe committees would often just list the name of the entity itself. And so under 1842110, instead the name field, we would clarify that the name should include the name of a human being, a natural person associated with the political activities of the LLC. And the reg would also provide that, again, if there's more than one person, any such person may be listed. And finally, for committees who receive contributions over $100 from an LLC that has already qualified as a recipient committee, the requirement would simply be that the name would be the LLC's principal officer. And so with that, I'm happy to answer any questions commissioners and Commissioner and Chair that you may have.
Commissioner Hayward, do you have any questions?
I mean, I don't have any questions. I think this is a fairly tailored and straightforward approach to the problem we have before us, which is finding a human being to be held accountable when LLCs are involved in our politics. And so I think this may solve the immediate problem in front of us. Not that there won't be further issues with attribution that come along once most of the rest of the state is subject to default contribution limits. But that's a bridge that's a ways away. So let's not worry about that one just yet.
That makes sense.
Thank you,
Thanks.
Commissioner Hayward. Mr. Lewis, I had a question for you. Can you give us a little bit of background on where did you and other folks draw your definitional terms for responsible officer from? Did you look to what other states have done? Did you look to other areas of California law? Give us a little bit of background on what did you look to in informing how you drafted this?
Sure. So essentially, what we've sought to do is to restate existing law, but clarify it as it applies to LLCs. So, the definition of responsible officer, I believe, one would find quite similar to the definition for IE committees and major donors, IE committees, I suppose, at present. And so we really haven't looked outside of the Act and our existing regulations or guidance. We felt this was more of a restatement and clarification of existing law as it applies to a specific type of entity where there's a lack of disclosure.
All right, thank you. Did you have anything further you wish to add, either Commissioner Hayward or Mr. Lewis, before we open it up for public comment?
No, I don't. Thank you.
Me neither.
All right, thank you both. So at this time, let's go ahead and open this up to public comment on the proposed regulations on LLCs. Do we have any public comment?
Hi, this is Ashley Titus from Bell McAndrews and Hilltack.
Good morning, Ms. Titus.
Good morning. My comment is primarily on the proposal in 18421.10. I would suggest that instead of including the responsible officer in the name of the LLC in the name of filer field, that you contemplate putting it somewhere else, either in the occupation employer field or description field or a memo field. As the Secretary of State's grappling with CARs and how to come up with a way to identify filers that are the same, when they're reported by different entities, they may be reported differently. I have a bunch of clients, and we may report them one way, and other firms or treasurers may report them another way. And I think you're going to run into an issue where if an LLC makes contributions with multiple different responsible officers from contribution to contribution, you're going to have a hard time identifying, at least in the software, which LLCs are really the same entity, because that additional information in the name is going to make it appear that they're different entities. And we have an additional challenge with LLCs in particular, LLPs, but even really any companies, trying to figure out which ones are affiliated with each other, and then when they are, what the name of filer should be, how to get to the top of the structure. Sometimes an individual is at the top, and sometimes it's a bunch of companies that are just affiliated based on their ownership or their direction and control. And so my comment is really just to encourage you to keep the name as the name and put the responsible officer information somewhere else in the data set for that particular donor.
Okay, thank you, Ms. Titus. We appreciate that. Do we have any additional public comment on the LLC regulations?
Hi, this is Ali Abdoli with Nielsen Marksmer.
Good morning, Ms. Abduli.
So good morning. Our main comment is just that the timing of this, as you know, I mean, so many businesses being closed and trying to figure out what they're doing. It's just been difficult to make sure to communicate this with our clients and get them to focus on these issues with, you know, basically them struggling to keep in business. And so we are a little concerned with the timing of this and not providing the right timing for people to really be able to focus and provide feedback when they're busy with so many, you know, other immediate concerns.
Well, thank you. I appreciate that comment, and I know that's reflected in the letter you sent to us, I think, last night or within the last 24 or 48 hours. Our intention is to try and use this as an opportunity to gather additional information and feedback so that our staff can continue working on this proposal. I don't believe that we have this calendared for adoption yet on a specific timetable. And so certainly we're mindful as we go through this that we may need to be a little bit more deliberate than we otherwise would be. But this really is an opportunity for folks to weigh in substantively so we can at least try and continue our work. So appreciate your comment, though. Do we have any other public comments on our LLC regulations?
This is Emily Andrews at Olson Remshow.
Good morning,
I
Ms.
just had, I suppose, a comment and maybe a question with respect to 1842110. The question I have is just on the side of recipient committees who are getting funds from LLCs, 1842110 seems to contemplate, you know, this additional information that the committee would be required to report with respect to the name of the filer and the full legal name of the individual primarily responsible for approving the contribution. And the question that I have is whether there's any thought that's been given to sort of what the timeline would be for requiring LLCs to provide that information, or sort of, you know, what the remedy might be for a committee that receives a contribution, has a requirement to report that within 24 hours and doesn't actually have the required full information at the time that they need to report the contribution. I just think that the timing on some of that is an issue, and that it's not information that the committee might readily have available at the point at which they receive and need to report the contribution from the LLC.
Mr. Lewis, did you have a response to the comment made by Ms. Andrews?
Yeah, I think our thinking was that the timeline and in general, sort of the requirement, the onus on the recipient committee in that situation would be the same as for any information that is currently required of them to seek from a contributor. So in fact, I was trying to find my footnote in my memo that I previously sent to the commission that addresses this. So forgive me for not having that in front of me right now, but the idea would not be to create an entirely new, you know, requirement for recipient committees in that respect. So hence why, in our view, it's simply a clarification of what's required in that name field, and not creating an entirely new burden upon recipient committees in terms of information they need to seek from a contributor.
So, Mr. Lewis, I actually have the benefit of your memo in front of me. It's footnote 5 of your memo dated February 20th, 2020. And as I understand this, and correct me if my understanding is incorrect, staff's thinking was that if the principal officer, responsible officer information was not provided within 60 days, that the recipient committee would have to return the contribution from the LLC at that point. And that is consistent, as I understand it, with the current rules for other aspects of the name requirement that already exists. Is that correct?
Yes, absolutely.
All right. And I believe that was a suggestion made by Ms. Titus at the February 5th, 2020 Law and Policy meeting. Ms. Andrews, is that responsive to your question? And do you have further comment if the time period was 60 days, similar to other name requirements?
It is responsive, yes, thank you. And with respect to 60 days, I mean, I think that is a time period that seems reasonable to be able to obtain that information. And thank you, I had not seen the footnote in the memo. I really appreciate the clarification.
Mr. Lewis, as a point of, I guess, clarification for the regulated community, is there a place within proposed regulation 18421.10 where we might want to make that explicit, that 60-day time period, or is there some cross-reference already here that I'm not picking up on?
So I think you're right, Mr. Chair, that there is no explicit cross-reference as I'm looking at it in front of me right now. I personally don't have a problem with adding such a cross-reference. Obviously, I'd have to check with General Counsel Bainbridge and Suki Brar to see if they agree, but I think that makes sense.
Commissioner Hayward, do you have any thoughts on this?
I think that makes sense. I think maybe what Emily was going after is if you have to file a late contribution 24-hour report, do you need to have the perfect name on that report? And I think that I can understand why that would maybe create some anxiety. Let's put it that way. But also, I mean, you know, if a recipient wants to have the benefit of the money in the contribution, then they need to identify names and sometimes addresses and occupation and employer and a whole lot of things. And so this is kind of this is an issue I think we've already had to deal with in other contexts.
Right.
That's all.
Mr. Lewis, I have a question for you, or perhaps Mr. Bainbridge, whoever wants to field it. But under our existing naming rules, the information that's provided to the recipient committee about the contributor's name, if that information is not transmitted quickly enough for the recipient committee when they are filing their 24-hour reports, how does that play out today under the existing naming rules?
That is a good question. I don't actually know off the top of my head.
Mr. Bainbridge, do you have thoughts on this?
This is Dave Bainbridge. I don't know off the top of my head either. Typically, they will file the report with the information and then obtain the information later and file an amended statement or report. But I can't remember exactly what the reg says in terms of that's sufficiency for purposes of compliance. But from a practical standpoint, I think that happens fairly often.
And is there any reason in your mind that a similar approach wouldn't be capable of being used here with LLCs? So if a recipient committee is in a period where they're subject to 24-hour reporting, they report the name information that they have at that time. And then if they receive additional information from the LLC, they would simply amend as a matter of course, like they do with any other contributor name information.
Yeah, there's no reason they couldn't do that. At a certain point, it loses its value if they're always getting filed and without the full name, and then the full name comes in later, especially for 24-hour reports when you want the information soon or immediately. But they certainly could file amended reports to add information later on.
Okay, thank you. All right, is there additional public comment at this time on the LLC regulations? Going once, going twice. All right, thank you. It was helpful receiving this feedback, and we will continue to reach out to the regulated community and other members of the public who wish to provide us comments as we consider these regulations. All right, and the final piece of our agenda today then, item 4, our legislative update. Mr. Bainbridge, do you want to provide the legislative update?
Yeah, I guess Jay is unavailable this morning, so I can cover it. Not much different from what we had at the commission meeting on Thursday. We received word from both the Senate and the Assembly elections and redistricting committees that they're going to be, when they finally get back in session, they're mostly going to be focused on budget and COVID-19 items. So I think much of the legislation we had sponsored this year may have to wait till next year. Beyond that, we had a meeting on Friday on the AB 2599, the e-filing of SEIs bill that we're working on with the author's office, and a productive conversation. Looks like that may be on hold till next year, but we're going to use the time to work with the parties and hammer out some of the details. Unless there's questions, I don't have anything else to add to legislation at this point.
I did have a question for you, Mr. Bainbridge. After the call that we had on Friday with Assemblymember Rivas's staff about that bill, my question is, I know there are provisions in that bill that deal with invitation-only events and gifts that an elected official may receive from that. And my question is, if the legislature is unable to move forward with PRA-related bills this year, is there anything that we can do from a regulatory standpoint to address the Assembly members, the issues and the concerns that her staff raised to us about some of the unique challenges presented by invitation-only event gifts?
Yeah, I think there is. I'd have to look at it because my recollection is much of that is already in regulation for returning gifts or buying down gifts within 30 days. I believe that's all in regulation. I don't think that's required by statute. So I think there are things we could address through regulation.
All right, Commissioner Hayward, what do you think about having Mr. Bainbridge take a look at that and report back to us at the next LMP meeting about what the regulatory options are for dealing with that issue?
Yeah, no, I think that's completely appropriate. Thank you.
Thank you. All right, Mr. Bainbridge. Hate to add to your stack of things to do, but I think we just did. So.
Okay.
All right. Thank you. All right. Anything else on the legislative front that you wanted to bring to our attention, Mr. Bainbridge?
Nope, nothing from me.
All right. All right. Thank you. Commissioner Hayward, anything further on our LMP agenda?
I'm chasing the sun around my room. No, I'm fine. Thank you.
All right. Well, thank you. And so in conclusion, I guess I would just thank the members of the regulated community who called in today under difficult circumstances, provide their input on the LLC regulations. Again, people can obviously send us letters, other written materials, provide comments as we consider this, and we're happy to consider their feedback and information. I also just wanted to highlight for folks that in May, we intend to do an IP meeting on behested payments. So again, this is it's important, I believe, for the commission to be receiving input and engagement from the regulated community as we work through these issues. So I hope folks will take the opportunity to engage us on behested payments as well. So if there's nothing else for the good of the order, do we have a motion to adjourn?
So moved.
All right, second, Ms. Linker?
Commissioner Hayward?
Yes.
Chair Matich?
Yes.
The motion passes.
All right, thank you, everybody.
Bye all.